So tonight we're going to talk about what happens if I die without a will or with an outdated will. I am Carissa Hanning, and my whoops. And I'm an experienced attorney dedicated to helping individuals and families make the very best legal decisions. I graduated from Monmouth College and Southern Illinois University School of Law. I've been practicing law since 2003, and I currently focus on estate planning and probate and have for the last 3 years. I live with my husband and my children in Bloomington, Illinois, but practice throughout the state of Illinois. An ideal estate plan can tackle many of your concerns. It can avoid estate taxes, although estate tax exemption is currently at the highest it's ever been. It is not permanent. According to the Tax Cuts and Jobs Act, the amount is set to sunset back to $5 million adjusted for inflation on December 31st, 2025. Therefore, many of you who would not have to worry about estate taxes today may need to reevaluate this concern in the future. Also, we can avoid income taxes. With estate tax a lesser concern for most people, the emphasis has shifted to minimizing income taxes. It can also protect the inheritance you leave behind for your loved ones. The last thing anyone wants is for your child or grandchild to spend everything you've left them during one wild weekend. And additionally, the right plan will shield the inheritance from those looking to take it away from your loved ones. Lastly, and for some people, most important benefit of a proper estate planning is control. When you plan, you are in control. If you fail to plan, the court will decide everything for you. This is very, very important. If you die without a will, the court decides everything for you. And let's talk about what the word estate means for a minute. Your estate is everything you own. It includes investments, heirlooms and personal property, bank accounts, home and real estate, other property, and it would all flow into probate court if you do not have a will. If you have done no planning whatsoever, it is very highly likely that most, if not all of these things would flow into probate court. I have probates open with every single one of these things in them. And in some cases, people tried to do the planning and they didn't update their plan. So we'll talk about that in a little bit. The pieces of these property will be held in by the probate court, where the judge will appoint someone who is then in charge of all your property, and they have to pay a bond. If you have not written a will, the person that the court appoints will pay a bond. And sometimes there is a fight over who will be appointed by the court, and the court then has to settle that fight, costing you your estate more money, because the attorney for your estate will then charge more. There will be probate fees. The fees in the state of Illinois are about $400 to $500 to file probate, another $200 to $300 to make it so that your publication is published in the paper so that your creditors have 6 months to come and see if they can get anything. You've also got to file taxes. You've got to do many different things. And your heirs are decided by the government through intestacy law. So if you are married, your wife is an heir and so are your children, or your husband is an heir and so are your children. Therefore, your wife would, in the state of Illinois, get 50%, and your children would divide 50%. If you've one, they would receive 50%. Two, each would get 25%. Each would get half of 50%, three, so forth and so on. So your wife could then own your home, or your husband could then own your home 50%, and your children would own the other 50%. That's a little crazy, isn't it? But that is how it would work if you had no planning whatsoever. If you did, however, decide you had some things in joint tenancy, we could have this same screen, but we can take out maybe your bank accounts. You own that in joint tenancy with someone, your home and real estate, and your investments and IRA account. Provided the remainder of your estate adds up to $100,000, we would have to go to probate court to get the rest of your estate dictated. Again, it would be dictated by the same things. The judge would be choosing all the people. If you have minor children and you are the only caregiver for those minor children, the court would also be determining who gets to care for your minor children. If you have no plan, anyone in your family can come forward and ask the court to take care of your minor children. And ex-spouses, everybody can come forward. Now, generally, if there is another parent, the other biological parent is still living, the court is going to give the children to the other biological parent unless there is a really good reason not to. And I mean really good. Like the other parent is in prison and you can't give children to a parent who is in prison. But then anybody from your family or his family could step forward, and it could be a hot mess trying to get a guardian for your minor children. As far as the things you had joint tenancy on, they may not have to go through probate court, but now only the person who is your joint tenant will have that item. So if you're an older individual with adult children, and let's pretend, as the thing has here, there are 3 adult children, you would be leaving your share to only one child. They have no obligation to share with the other 2. The house, the investments, the bank accounts, anything you have in joint tenancy or a beneficiary with that child would have no obligation to share any of that. So you may have unduly made it so that one child made out like a bandit and the other child got the house and the mortgage that went with the house. Not ideal, correct? So if you are in a situation where you are only planning with joint tenancy and beneficiaries, or you have no plan whatsoever, please call an estate planning attorney and have a conversation about if that is the right plan for you or not. Most estate planning attorneys do not charge for a consultation. We do not charge at Hanning Law Office. So if you would like to have a consultation about any of these things, please give us a call. You can even message us on the website, and shortly we're hoping to have the ability for you to schedule your own consultation on the website as well. Now let's talk about an out-of-date estate plan. Some out-of-date estate plans are abso-freaking-lutely worthless. Let's talk about the birth of a child. A common time for people to come to me and get their estate planning done is when a child is born. And I check in with my clients, and every time they have a child, we review and change their estate plan. However, that is not true for every estate planning attorney. An example here from California is Kobe Bryant. When he died in the helicopter crash with his oldest daughter, he had created a trust in 2003. And up until the birth of Capri, he had amended it to include every child as they were born. However, he had not amended it to include Capri. When Capri was born, for whatever reason, he didn't get it amended. And Vanessa had to go to court and use some language that was in the trust to get Capri added to the trust. She was added to the trust, but it did cost the estate some money to do so, as well as Vanessa. I am pretty sure that is not what you would want your family to have to do to include one of your children. Same for a grandchild. If you are like Ted and Gladys here, and you want to make an educational trust or an educational fund for your grandchildren, and you make one for every individual grandchild that is alive at the time you start making the trusts, and then, or the 529 plans, and then someone has a kid and you pass before you are able to get one made for that child, there is no way to make one for that child as part of your estate plan without some very specific language in your estate plan. So if you have an estate plan where you are preparing to provide for your grandchildren, please do consult an attorney every time a grandchild is born. Death of a family member is probably the most important change that we need to talk about. The client could come to me, a will maker or trust maker, and they have beneficiaries, personal representatives, executors, successor trustees. They have all these people in their plan. Each of those people, if one of them passes, can cause a problem with your plan. It can make your plan take longer to get done, and in some cases can make it so it's as if you didn't make a plan at all. So let's talk about Stacy. Stacy is a single woman. She has a will that names her mother as the only beneficiary. There are no contingent beneficiaries. The beneficiary is who gets what Stacy has. Her estate's not huge, but she does have enough. And Stacy and her mother go to Costa Rica and are bungee jumping and pass away together in Costa Rica. Well, Stacy's family that is left back here does file her will, and they open probate for her. And they find out that she only had her mother as a beneficiary, meaning there was nothing there. So essentially, the judge has to act as if she had no will at all, thus going to her estranged brother, who she hadn't talked to for 15 years, and he gets her entire estate, not someone else that she would have liked. I encourage my clients who are single and have no one that they can name as a contingent beneficiary to consider some charities that they really do appreciate, so that they are able to give the information give their estate to who they would like to give their estate to. Death of an executor, a successor trustee, or personal representative can cause big problems too. Roger, he formed a revocable living trust, and he named his wife Janice as successor trustee. He also named Joan, Jason, and Charles as additional successor trustees. Roger, Janice, and Joan go to visit Roger's mom. They are in a car accident and pass away, all three of them. However, Roger's administration of his estate occurs very smoothly and without any court involvement, because he has a trust and he has named Jason, who was not involved in the accident, as a successor trustee. And Jason can show the death certificates for Janice and Joan and step right in as successor trustee and take over. This holds true for your wills as well. If Roger had just a will, but he had named Janice as executor, Joan, Jason, and Charles as additional successor executors. Those are big, hard words to say all together. And then Roger, Janice, and Joan passed away while visiting Roger's mother. Administration would still occur pretty smoothly, because we could show that Janice and Joan had passed away and Jason would need to be executor. So if you have an estate plan where someone has passed away as part of that estate plan, you really do need to get that updated so that it's easier for people to inherit, the people you want to inherit your things, get to inherit your things, and B, run the estate smoothly so that everyone can make sure that everything happens. Here at Hanning Law Office, we check in, and when we check in yearly, we ask about the death of a family member. We also ask about any other thing that could change your estate plan, so that there aren't big major changes to be made. We can make minor ones and it's not a big deal. Purchasing a new home. A lot of people don't think about updating their estate plan when they purchase a new home, but it really should be updated, whether you have a will or a trust-based plan. It's easy to transfer by deed when establishing a trust. And if you don't have a trust and you just have a will and it's your first home, In Illinois, we have what's called a transfer on death instrument that we can add to your house to make it so it can come out of probate and you can leave your house to whoever you would like, but still not have to go to probate court as we discussed earlier. And if you purchase, let's say, a vacation home in another state, we're going to talk about that in a minute, we might need to consider a trust so that you can have everything protected and not have to go through probate in 2 states. So let's have a chat about that. For example, Roy lives in Illinois, and Roy purchased a vacation home in.
Before you try putting it in. I was like, who packed the peanut box?
Hi. Okay, let's go back to Roy. Roy lives in Illinois, but he purchased a vacation home on the Gulf Shore, and it's only in Roy's name. So it's not in anybody else's name. It's just Roy's name. Roy passes away. Now we have to have 2 different probate proceedings to be opened, one in Illinois and one in the state where the vacation home is located. So now the probate got even more expensive. In this case, if Roy had went to talk to an estate planning attorney, Roy would have been encouraged to get a trust where he could put both houses in the trust, and we wouldn't need to open probate in either state. So if you purchase a new home, a vacation home, something along those lines, is the best time to at least have a look at your estate plan if you have one. And if you don't have one, it's a good time to get one so that your estate can go where you want, including your home. You can pass your home with the mortgage that is on it, and your family can sell the house and pay off the mortgage and still inherit from you. Another really good time to update your estate plan, or at least get one, is when you get married. Estate plans help keep ownership of money and property straight, outline your wishes about what gets left to your spouse, and determine who has decision-making authority for you. In order for your spouse to have any authority or receive what they are entitled to, a probate court would have to be involved. So let's talk about Emmett. Emmett got he in 1999 as a single man. He created an estate plan, which was great. And he named his sister Betty as his agent under the financial and medical powers of attorney. In 2001, Emmett met and married Lucy. Emmett and Lucy go to Hawaii on their honeymoon, but Emmett falls off the balcony and goes into a coma. Well, Lucy tries to go and deal with all of Emmett's affairs. She tries to talk to the insurance company, the hospital, all the people. Well, it is found out that Betty is the one who can make the decisions for Emmett, despite Emmett being married. Unfortunately, Emmett is now got all of his decisions for Betty. So the other situation where you might want to get new documents made, and the last situation we're going to talk about, is getting divorced. A client's ex-spouse could be named as a personal representative or executor or beneficiary or power of attorney. State law varies about the impact of a divorce on estate planning documents, but in Illinois, the only thing it changes is your will, and you have to go to court to change that will. You have to go to court to get the spouse taken off, the ex-spouse taken off. They would still be able to pull the plug on you if they were your healthcare power of attorney. So it is best, if you are getting divorced, to also get your estate planning documents in order. Also, it will avoid confusion and have your best to have your wishes clearly laid out. That is the end of today's town hall. I'm going to open it up for questions now. I'm going to stop the share and I will open it up for questions.